Welcome to everybody. We are in Ant Institution here in Bologna. Ant Foundation is a charity organization. We do palliative care for cancer patients all around Italy. And we take care of 10,000 patients a year, completely free of charge, thanks to donations, thanks to public health, with whom we have a link, of course. And we do research too. And we are here with KNIME organization, yes, in order to do other projects together for our patients. And so thank you for coming here. Thank you to everybody who are listening to this meeting. And so now, thank you.
Okay, so now it's my turn. Yeah, so today we are here for, it's the first, I'm very proud to witness this moment. It's the first time that we have a data science for lawyers. I know it sounds strange, but apparently lawyers use a lot of data analytics, and Professor Sapienza will explain to us exactly what they do. So I hope you will enjoy it. I am very curious to see what the topic is going to be. And yeah, so let's start. You want to say a few words about you?
Yes, so thank you, first of all, for organizing this event, Rosaria, and thanks also to Ant for hosting us. So my name is Salvatore Sapienza. I am an assistant professor, as you can see from the bottom of the slide, at the Department of Legal Studies. And first, huge disclaimer, my background is a legal background. So I have my LLM, my PhD was in law, science, and technology, but since 2016, I work in the field of legal informatics, which is one of the topics that we are discussing today. And today, I'm very happy to present some, say, insight about what I do, both at teaching level. We also have the pleasure of having some of my students here. Good afternoon. And also in my career as a researcher. And so today, my idea is just to present to you the way we use KNIME and in general data analytics for legal purposes. First, I have, if this thing works, should work because it's okay. Yes. I have to start from some methodological premises. Now, I don't want to sound like a professor now, but I have to say something about what makes legal language different from other languages. The first question that I have to ask is, why do legal operators need to have data analytics competencies? So why is it needed now in 2024? Why should lawyers deal with these topics? Well, this is one of the answers. This is taken from LexisNexis. Lawyers know that this is a very popular database for case law and legislation. So basically, you can find jurisprudence in such tools. Of course, for you have to subscribe to these tools, but you also get some interesting analytics. So what used to be just databases of case law has become platforms that also offer some kind of data analysis tools. And our idea, our intuition is that lawyers in general, especially law students that are basically future lawyers, will need the competencies to understand what's going on behind the scene, why algorithms are telling them that there is a trend in the case law and how a case will be decided based on the previous cases. But why lawyers? What makes the legal domain different? Well, we know that legal theory basically includes some parameters. So time and legal validity. A piece of legislation is in force now. It wasn't in force yesterday. It will be in force in the future until the law is repealed and the new law is passed. Jurisdiction, temporal, spatial validity. a law that is valid in Italy will not be valid in France, unless it's a European regulation, of course, but in many instances, law will only be applicable in a certain territory. The same goes with constitutive rules. X is appointed as mayor of the city. That's a rule that is a constitutive rule. Now, that person acts as a role. There are legal definitions, there are exceptions and derogations, there are very complicated legal concepts such as bona fide, and so on and so forth. So what I'm trying to tell you is that legal language is completely different from natural language. And today we will also see some examples. For instance, rules. Article 3 changes over time. Article 3 of any piece of legislation is prone to change, is subject to change. Concepts such as minor have different meanings in legal terms. For instance, in the GDPR, minor, so the General Data Protection Regulation, the concept of minor is completely different from other concepts of minors that we can find in natural language. There are also definitions that have specific legal value, such as definition of personal data or definition of data processing, and so on and so forth. So we need a specific methodology to process legal data, whatever they are. Okay. How do we develop this methodology? Well, in research, this is one of my proposals. This is a fully fledged methodology that basically puts together people with a legal background, let's say lawyers, with people working in IT, so technicians, in order to develop an hypothesis, formulate it, find possible research questions, structure experiments, validate the results, both from a technical and a legal point of view, also keeping into account the fact that we also have law and ethical principles that also steer somehow the kind of practices that we can adopt. And finally, we find answers to research questions, but you see there is a methodology that we want to adopt. So the conclusion of these methodological premises is more or less the following. Future lawyers need to understand why and how legal analysis is complex. They have to keep into account legal principles and the rules that now or in the near future will apply to these data-related practices. Finally, okay, we got support by KNIME because the accessibility and the readability of the platform allows even law students, so people that are not yet practicing law at a professional level, to, let's say, I wouldn't say bypass or circumvent, but to use data analytics while focusing on the legal analysis. They don't have to keep into account their background, their technical limitations, because they can use the platform in order to develop legal analysis in a much easier way than, of course, in the past. And also, this is another, I think, key takeaway. Being prone to understanding how legal analysis works when it's, let's say, computized by some kind of algorithms, increases the capability of working with interdisciplinary teams. This is something that I do in my professional life because, as you will see, most of our research products are developed by joint teams where you have the lawyer or the lawyers and some people with IT backgrounds, usually data scientists. But this can happen also in other environments, in other working environments. My understanding is that law firms are progressively developing tools to help their lawyers, but they are still separating the IT people from lawyers. And we don't believe that this is the right approach. We instead believe that there should be some kind of integration. And we also think that approaching KNIME is a good way for developing this kind of interaction. Now, the first part will be dedicated to building knowledge for you in what makes legal analysis different from other kinds of analysis. And I will introduce the data science for lawyers course that I have the pleasure and the honor to teach at the University of Bologna. Then the second part will be more dedicated about the research and some experimental features that we are trying to navigate also with the use of KNIME. So first, what is legal data? So can be, when we think about data, at least from a lawyer's perspective, we usually think about a table with some tabular data in it, some variables, data types, etc. Well, the law was an exception until some 20 years ago, because progressively law became from pure paper, let's say, to something that is more datafied. The reason is pretty straightforward. The first example we see actually in Italy in the 80s, the first experiments, but then of course this has become a more consolidated trend in the future. The idea is that the more we rely on ICTs, the more we also need the law to be processed in automated ways. And there are ways, of course, to process the law. I've just listed some of the platforms that can be used. And I will also talk about more this structure. So with the transition from paper-based law to digital versions of law, for instance, digital gazettes or cases, data analysis has become possible, because before that it wasn't. Okay, till the moment that law was just paper, data analysis was basically impossible. With law being in computer readable, machine readable formats, then analysis becomes possible. The idea is that you can do something, for instance, some kind of analysis to answer to legal questions. For instance, is there a pattern in the case law? Are judges judging in a consistent manner? How has the law changed over time? Can we monitor the evolution of law over time? This was impossible some 20 years ago. Now these are things that we can do. The idea, ultimate goal, is to have better legal decisions. Now, this better legal decision has a lot of nuances and possible meanings. It can be faster, can be cheaper, can be more fair, more just, more transparent, and so on. And there are, of course, many possible interpretations of what a better legal decision means. But the idea, the ultimate goal of all these research trends is to have better legal decisions. Then, of course, depending on the person who you ask, the answer could be different. But overall, let's say that that's the ultimate goal. There are some challenges. For instance, it's not just about more data. It's actually about having better data. I'll tell you why in a second. There are, of course, many stakeholders involved. As I was saying before, asking what's a good legal decision, well, the answer depends on who you're asking. Law firms have a different idea than, for instance, members of the parliaments or judges, decision makers, researchers. And there is also another problem. There is the compliance. We'll talk about that at the very end of the presentation. The fact that legal compliance will be needed. So it's not just about having data and analyzing them, but also analyzing them in a way that is compliant with the law that will regulate this data analysis. First challenge and the first topic, unstructured versus structured legal data. What you see on the right-hand side of the screen, well, you barely see it, but you can trust me on this, is a regulation, is a very well-known regulation, I think the best known regulation in Europe. There is the General Data Protection Regulation. It's basically the regulation that applies to literally anything, including my voice being recorded. It's a regulation that norms the processing of personal data. Most of the legal data is available in a PDF format, which is our worst enemy, because PDF is not structured, and the natural language processing analysis is very limited by the nature of the PDF. PDFs are not very well, I mean, they are machine readable, but they are not structured, so they don't provide any information about what, for instance, is personal data in this specific context. This is a definition, and from a legal point of view, this is extremely important, the fact that personal data is a legal definition that has a certain meaning in the law. The same goes with other legal elements. Time, jurisdiction, cross-references. I'm referring to Article 3 of another piece of legislation. That reference, to that reference, natural language processing tools are completely agnostic. They don't even know that Article 3 of regulation is a legal reference. And this is extremely important from the perspective of a lawyer. Usually, in my experience, data scientists underestimate the impact of legal references. Instead, those are crucial because allows us to allow lawyers to understand what's the legal meaning of a given provision truly is when there is a reference. Also, PDF is completely agnostic to the structure of the law. The structure of the law is extremely important. We have chapters, articles, paragraphs, subparagraphs, and so on and so forth. This structure is crucial in understanding legal documents. PDF, the one that I showed before, is completely agnostic. It's just new lines. And for us, this is completely useless. But luckily, some people, including my supervisor, Professor Monica Palmirani, and other professors, are working on they have already developed a pretty widespread international standard for marking up legal documents in XML. This standard is named Acomantoso, and as you might see, in this case, personal data is labeled in XML as a definition. So we know, for instance, that that specific piece of the provision that is within the brackets that define a definition has a different legal meaning in comparison to all the other text. Plus, again, this is structured XML, so we also have the structure of the document. We can see the number of the article, the heading, all the articles are listed, and so on and so forth. So the understanding of the legal document is much deeper. All the legal elements that lawyers should take into account are kept into account thanks to this standard. Okay, so the idea is the following. If we have this, if we have structured legal data, then we can have better textual analysis, at least from a legal point of view. And here is where KNIME really helps us. These are just some ideas, some preliminary ideas. I will show, of course, I'll show you some many examples of research products and other research ideas. One idea could be, for instance, having a citation network. So imagine I have all the textual references in a document. What I can do is to build a citation network that encompasses all these citations. This is extremely helpful, for instance, in case law. I have case A that refers to case B refers to case C, and case A refers to case C. I can create a network, I can explore this network, and this is extremely helpful for drawing legal conclusions. And just a small prototype with KNIME. I hope people at home can still see my screen. I guess so, because I see it here. So, for instance, this is one. I have the folder with all the XML files. In this case, these are FAO resolutions marked up in the Acomantoso standard. I can find the text that I want in XPath. So thanks to the XPath node, I can filter, I can manipulate my strings, etc., etc. And then at the end, what I can do is to have some kind of visualization like this. Of course, this looks extremely messy to your eyes and not very responsive, but I can easily understand, for instance, that here, this provision from FAO has been cited many times. So it must be central in the architecture of FAO's resolutions. Without this kind of analysis, without these tools, this kind of analysis is extremely complicated because you have to read manually all the FAO resolutions, try to underline whether there are connections, nodes. Instead, having structured data with a very easy and straightforward KNIME prototype, I can easily visualize all the connections between these legal documents. Okay. This is just an example, of course. Let's see in practice other a bit more, let's say, complicated things that can be done. If I have a structured data, well, I can read PDF. Not very happy about that, but it's okay. Still doable, so we can do it. Instead, if I have, let's say, a collection of XMLs, then I can read them through KNIME using XPath and refer to the part of the document that I need. Then I have a very powerful data type that is the document data type. I really appreciate it because it can be very helpful, of course, for legal analysis. And what follows after the conversion from any given string of text to a document is a data pre-processing. Now, what I always tell my students is that in the legal domain, data pre-processing is dangerous. So you have to adopt a lot of caution. Why? Because every part of any piece of legal document is important. Removing information, removing frequent words, removing numbers, removing, I don't know, other elements of the sentence, frequent words, let's say, as some kind of legal implication. So it's important to adopt a lot of caution in the data processing. But if we know what we are doing, as I always tell my students, if we know what we are doing, then we are safe. At least we have to also justify it from a more legal point of view. These are an example of a pipeline that I usually use. For instance, removing stop words, so words that are common in the English language in this case, stemming, so removing the final part of the word, erasing the punctuation, filtering numbers, filtering short words, converting everything to the lowercase, and then I can do something a bit more complicated. Now, as you may know, words can become numbers. Well, they can become vectors, to be more precise. There are ways of transforming a given set of words into a vectorial representation, and this is exactly what I usually do. One way could be using TF-IDF. Now, TF-IDF is a matrix that basically measures how relevant is a word in a given document in comparison to other documents. On the basis of this TF-IDF matrix, I can transform the string of the document that I have, the string of words that I have, in a vector. Of course, then I have to apply some kind of post-analysis, because what we usually get, sorry, let me go back to KNIME. So what we usually get, this is other filtering operations. Okay. I don't see what I wanted to see, but it's okay. Okay. No problem. What we usually get is a very long list of columns that have to be somehow reduced. One way of doing it is through TSNE. It's an algorithm, unsupervised algorithm for reducing the dimensionality. Another way could be applying some other techniques. For instance, topic extraction. Topic extraction is always very powerful because it allows us to have, let's say, a broader understanding of what are the topics covered by any piece of legislation, any case, and other legal documents. Again, we have to use some kind of machine learning methods. One is LDA. Again, we also use TSNE to compress the dimensionality of the dataset. Now, I wanted also to give you an example, but I cannot. Okay, good. Okay, so for instance, here, I've already prepared a dataset with some fines of authorities, okay? These are the sanctions that are issued on the basis of the GDPR. Imagine lawyers want to know what are the topics, or say how close these judgments are in this dataset. Dataset is composed by many columns. The important one here is the summary column. Summary columns gives us a abstract, a summary of the case. So for instance, here I've already removed some things that I don't really need, some rows that add some missing values. I'm ready to transform in everything into documents. As I said before, the string to document the document data type is extremely important. There is another reason. I can also use metadata. I can embed in the document data type some metadata that are very important for legal analysis. For instance, the country, for instance, the authors, the authority in this case that has issued the sanction. So I can apply, and after this, I have my document column here on the right-hand side of the screen. What you can do after this is just to apply all the processing that I said before. So for instance, I initiate by removing common words in the English language, and I execute. Of course, all of this analysis can be easily refined. I'm just rushing through it just to give you an understanding of how easy with KNIME is to arrive from a data set with just some strings, some abstract of cases, into a visualization that is extremely interesting for legal purposes. And I'll tell you why at the end. So stemming, I'm just removing the final word of each word in order to have everything standardized. What else? Punctuation. I could also ask my students. I guess they are prepared about this. I won't. It's okay. Number filter. Yeah. Can remove filter terms that represent numbers. Now, from a legal point of view, for instance, if I have Article 13, I am removing the number 13. This is a huge loss in terms of legal perspective. Okay. But in this case, it's fine because my research question, what I'm trying to understand, does not have to do with the use of that kind of Article 13, that kind of legal reference. So I know what I'm doing, and it's fine. I can do it. But I have to think from a legal perspective that removing numbers means also removing articles, the number of articles. So what I'm doing here is just all pre-processing on the basis of this. I'm just checking whether everything is working fine. Okay, that's fine. I've pre-processed the document. Of course, I want to keep my everything in order. So I am only working on a column that is called pre-processed documents, where I'm applying all these pre-processing. And I'm good because I'm always replacing it. So I'm keeping both the original one and the other one. Okay, and now there can be another way, which is interesting, with a table writer. Sorry, table creator. Yeah, should be this one. I can remove words that are very frequent that I don't need for the research question that I'm working on, even though they have some kind of legal significance. I can customize the words that I don't need. For instance, fine. For instance, I know for sure that euro is going to be there. Data is going to be there for sure. Personal data, it's surely going to be there, and I don't need it because I'm trying to understand what are the topics covered, like surveillance, like employment, stuff like that. I know that I won't need personal data, euro, fine, etc. So I create this table, and I can work with a dictionary filter, for instance. So I can also very easily customize the kind of words that I have to use. Now I don't remember exactly. Let me see the original so that I remember the process. Now we should be good. Dictionary filter. But should be this one. Don't remember. Okay, yes, I forgot to click apply here, so wasn't finding anything. Okay, so we were saying GDPR, personal data, fine, euro. Okay, say want to do this. Okay, of course, I have to remove it from the pre-processed document. I'm fine. And now I can create a bag of words. So the bag of words basically creates a literally bag of words. So I have a huge document and I can separate each word from the other in a way that I can calculate the frequency in a document. Okay, so what I'm doing here, okay, sorry, I have to also keep everything else from before. That would be important later. So I'll show you the final result. As you can see here in the very last column, each word has become a row of this data set. Of course, I am still bringing with me all the original data sets. I just have one word for each row. The data type here is very important because it's term. With this term data type, what I can do is to calculate the TF. So the frequency and first in the pre-processed document, of course, and the IDF. TF and IDF allow me to understand how frequent is a word in a document, how relevant is the word by calculating the frequency of the word in that document and the inverse frequency of that word in all the other documents. So if I have a document that talks about cats, there will be a lot of references to cats, okay? Instead, all the other documents are about all the other animals. The TF-IDF of the word cat for my document will be very high because it's very frequent, whereas it's infrequent in other documents. After this, I can multiply TF and IDF, and so TF multiplied by IDF, I create a new column that I will call TF IDF. Okay. After this, I have a new columns with the TF relative, the IDF, and the TF IDF. This magic number will allow us to do something interesting. That is the vectorization of the document. So these documents, these cases, let's say, will become vectors. And basically, on the basis of the TF-IDF, each word of each document has become a number that represents the frequency. And if two documents are the same, they will have the same numbers. If they are distant from this vectorized perspective, they will have divergent numbers. Guess what? This allows us to do case similarity. If the vectors of two documents are similar, then it means that the wording that they have used is similar. It means that the cases are about the same, say, subject matter. Of course, I have a lot of columns here, so I can use TF-IDF, which is the magic algorithm that reduces the dimensionality of all these 3,000 columns to just 2. Again, I'm losing some information here, but I'm fine. And then while it does so, I am ready to retrieve. If you remember, we embedded in the document some metadata. I told you I can embed document class is very important because I can embed some metadata. I can retrieve metadata and use them for my legal analysis. In this case, I will retrieve the authority, and I can do something like this with a color manager. I can be ready to, of course, visualize. Each authority will have a specific color, and finally, I can visualize everything with a scatter plot. I have 2 dimensions, T dimension 1, TSD dimension 2, and we should be good. Let's see. Yes, this is the visualization of legal documents. I think it's the first time you see anything like that. And you see there are some documents. Of course, colors are not that bright in that visualization. I hope that from home in the screen it looks better. Of course, this visualization can be customized in 1,000 billion ways. But the concept that I want to represent here is that case similarity can be detected by these sorts of visualizations. Some years ago, this was impossible. Now we can extremely easily do it. Okay. And this is also very good for legal analysis, because imagine I look for spots of cases that are similar. I don't have to read the 200 cases to understand what cases are about the same subject matter. Also, I can see that, and this is a legal conclusion that I can already draw, from the visualization, I know for sure that some authorities have talked about similar subject matters, whereas some authorities have talked about something else. From a policy perspective, this means that some authorities are more keen on investigating certain data processing related issues. Some authorities instead are dealing with something else. Authorities will be on video surveillance. Some authorities will be on marketing online, something like that. Okay, there is another example. Of course, I don't think I have the time to go live with this, but the idea is that you can also do topic extraction. In practice, there are things that you can also extract topics. Now, very quickly, I think that for the first time, I have some minutes, which is good. For the first part of the presentation, I have some minutes. I want to talk about, after this, very kind and straightforward introduction to legal informatics, about what we do in the School of Law. We offer this course in the Legal Studies LLM. It's offered to international students, and also it's also taught at the Law Science and Technology PhD program, which is my, it's the PhD program in which I graduated in. We offered this course. We offered it since last academic year, and from the 1st of October of last year, it's also under a Jean Monnet module. If you're unfamiliar with Jean Monnet, is essentially some courses that are considered to be excellent courses by the European Commission because they are extremely innovative or for other reasons. We have a project called Let's for Excel, Legal Design and Data Science for Explicable AI in the Legal Domain. That is coordinated by my supervisor, Professor Palmirani. This course now also falls within the Jean Monnet program as a Jean Monnet module, which means also for the curricula of the students, it's a plus. Sometimes my understanding is that some especially at university level, attending a Jean Monnet module is something that is considered positive. Most importantly, the assessment is conducted mainly with KNIME. We provide the opportunity to assess the group project, assess the exam with a variety of tools, but usually students prefer KNIME and Jeffy. It's a group project that is not only about legal analysis, it's not only about quantitative analysis, we also do that, and I'll show you. But we also care about the ethical and legal implications of the research projects. Okay, so it's not just about data analysis for the sake of data analysis. We also care about what they consider to be right, wrong, compliant, and so on and so forth. Because it's not, again, just about analyzing data. We have to do it in a safe and, of course, legal manner. And we also teach them how to assess legally and ethically their projects. And we ask them to report on this. Some other information, that teachers are me and my supervisor, Professor Palmirani. We also have the pleasure of having some guest lecturers. Professor Ashley, who is also the author of the book. This is in my honest opinion, there are many books that are extremely valid in data science for lawyers, in the universe of data science for lawyers, but this is a must read, in my opinion. Artificial Intelligence and Legal Analytics by Professor Ashley from the University of Pittsburgh. We have also Professor Ashner from the University of Ottawa. He is the father of the expression data science for lawyers. We have Francesco Sovrano now is a postdoc at the University of Zurich working on explainability. And basically, our teaching method, as you can see also from the diversity of people that are teaching this course, is very interdisciplinary. We promote a lot of interdisciplinarity and learning by doing as a methodology. So my usual classes are KNIME tutorials where I just open KNIME and I start analyzing and say, okay, you should do this, 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 and that. If you do this, then this happens. If you don't do this, this happens, etc., etc. Last year we had 23 students. This year we have more than 35 students. I'm not sure about the exact numbers, but so far we have 100%. For sure, we have more students than last year, which is good because I think that it helps us also to understand the diversity and the background of more students, and also we improve as teachers in this very experimental course. What are the objectives? I think that now you should have a better understanding of what we try to do. Technical and legal knowledge about data. What is personal data? What is non-personal data? What is open data? Some interrelated topics about data analytics and what are the policies that regulate all of this. Unfortunately, or fortunately, depending on the perspective, we are also lawyers, so we have to teach them what's the law that regulates all the processing of this information, the GDPR, FOIA, the PSI2, licenses, copyright, the AI Act that is being discussed today, the Data Act, the Data Governance Act, and so on. And introducing also students to some practical tools for data analytics, which are the ones that I mentioned before, of course, including KNIME. Okay, now some of the group projects from this year, they assessed also, I think they're presenting you your groups. So this will look familiar. I apologize if I'm oversighting like 99% of your project, but basically what they're some projects. This one is irregular migration in the European Union by students, Maximiliano, Sebastian, and Miguel. What they did was very interesting because they combined data about migration with European Union legal documents to see how the law has changed in comparison with how migrant flows have changed. You can see a snippet of the research of the group assessment. Of course, it was much bigger. This is just a screenshot. And these are the results. Basically, what I noticed, that something surprising even for me, is that looking at the evolution of the European Union documents in the subject matter, there is an increasing stress on the word return, which means it's more frequent. Okay, from a legal point of view, it tells us that there is something different. Of course, we don't know to what extent this is different, but at least we have an intuition, let's say, something that tells us that it's a good path for developing a more deep legal analysis. And they've also observed a decrease in the number of migrants. This can be related to an astonishingly high amount of factors, but there is something. There is some correlation that lawyers can explore. Of course, at the end, we can also say, no, we were wrong. There are other factors to keep into account, but at least we're keeping into account some legal factors, which is something that nobody has done before. And of course, all of these, also the visualizations were done with KNIME. Another group analyzing the impact of the Equality Act 2010 on gender pay gap in the UK by Miriam, Michaela, Nikita, and Valeria. Sorry for pronunciations. This is quite similar, but interesting from other completely different perspectives. So they provided a textual analysis on two UK acts about gender pay gap and the numerical analysis of the actual gender pay gap. This was, again, very interesting. They provided a very interesting visualization about the words that are more frequent in these documents. Equality is, of course, at the center. We also have pregnancy, power. And I think from a legal point of view, this was very interesting. They differentiated the colors depending on the act. This is something that I found very original because it was the first time I actually saw this kind of visualization from a legal perspective. This is again a very confused screenshot of their workflow. And what I found very interesting is that for the first time in these 2 years, I have assessed, of course, many groups, but they used the anonymization node because they had personal data. They knew that processing personal data is complicated. We have to understand how it's done and why. So they decided to anonymize all the data to provide for further analysis. And they actually used all these visualizations to gather some results. And they were very honest because they said, okay, there is a decrease in the percentage of gender pay gap, but we don't know how much this is correlated to the actual enactment of a new piece of legislation in 2010. And this was correlated by this very good number of visualizations that told us many different conclusions here. Of course, sorry guys, I'm summarizing a lot, but this workflow was very complicated. Also, remember the presentation was very long and complete because they were looking at all the data. Again, this is a very good example of combining tabular data with legal data. This can be helpful in many instances, especially for policy monitoring. There are lawyers, of course, that do advocacy, lobbying, policy monitoring. These methodologies can be useful for them. Okay, some lessons learned from this experience in the data science for lawyers. Interdisciplinarity is key. Okay. Of course, we are not Leonardo da Vinci. None of us is Leonardo da Vinci. We don't have the skills that we put together: poetry, painting, architecture, and stuff like that. But we have to set a dialogue. Okay, and I hope that these new generation lawyers that I have the pleasure to teach will also bring this with them in the future. One of the key takeaways is that by understanding how legal analysis, how data analysis is performed in a very simple way, let's say, students can also understand how the law affects this data analysis. They have a completely different practical approach. This is also due to the learning by doing. And I think that this is a good methodological approach, trying to understand, trying to answer legal questions from also by using the empirical validation of data analysis. Of course, this would be an heresy in the ears of many lawyers and legal scholars as well. But this is an approach that we are trying to experiment. And my impression is that it's somehow working. There was a comment from, I think this year, you guys can correct me, but this year, one of the students told me, I worked for years in a law firm. I wish I knew how to do this before, because apparently his job was manual, was a lot of reading. And he told me that he wished literally that he had all this knowledge while he was working in a law firm. So I genuinely believe that these kind of soft skills can be helpful also for the placement in the job market. I really hope so. And my idea is that teams will be integrated more and more. So we will need some kind of interdisciplinarity. KNIME is a good trade union, in my opinion. This is my final comment before part 2. KNIME is a good trade union because it allows to develop some prototypes, some intuitive data analysis that can also become more and more complicated. I'll show you some examples in the second part. But at the end of the day, it removes the barrier that people without a technical background, the data science background, can have in approaching data analysis and in talking to people with a different background, so in data science. Okay, end of part 1. Break, no break. I need to drink a glass of water. Questions, of course. Questions first before questions. Yes. Okay. No, okay. Okay. Nothing so far. It's okay. You can take a... Yes, sorry, they didn't hear you, of course. For people online, yes, if you have questions, you can use the Q&A. I have the chat in front of me, so I can read it. Nothing so far, but I mean, question? You can.
Do you work with English documents? Do you have some problem with documents from different in different languages?
Yes. So 99% of NLP tools work fine with English. Okay. In my experience, this is a problem, of course. We are trying to say, so the problem is again with structured data. We are trying, not me in the first person, but the people that I work with, especially Professor Palmirani, are trying to enlarge the number of legal documents that are structured in different languages. For instance, FIO resolutions are available in Russian, Arabic, which is good because at least there is something that can be done also with other languages. In a paper that was discussed 1 month ago, we performed that. Unfortunately, I didn't have the workflow for bringing it to you today. But the paper is completely accessible. We used KNIME to perform some analysis that was similar on case law in 4 different languages: Italian, French. Thank you so much. Italian, English, German, and Spanish, these 4 languages, and the results were comparable. So I must say that the state of the art in NLP is getting there. Okay, the problem is document availability. The real problem is document availability. For instance, France, I was having a chat with my supervisor today. France has a program that is called LegiFrance, where all the legislation is available in structured text for the French language. In Italy, we have it as well. Case law in Italy, at least, is 20 years behind because they are still doing everything with PDF when it's the best case. Worst case is handwritten because some rulings are still handwritten. I mean, they're written with Microsoft Word and then exported in PDF, then digitally signed, but some notes are annotated by hands by judges. So that's where the real problem is. So to reply to your question, the state of the art for multi-language problems is getting there, not big deals. We can do also KNIME as many libraries that can help with multi-language. The real problem is with the lack of structured legal data. Yes, please.
So your students are law students. How do they handle that?
You should ask them. No, they are students from law. Most of them have legal backgrounds. Some of them have backgrounds in international relations. Some of them have backgrounds in economics. Some of them have also previous experiences with coding abroad, not in Italy. Okay, especially students from political science, international relations. Some of them have some background in quantitative analysis, but none of them has a background in legal text analysis. How do they handle them? Well, sometimes I'm surprised by the depth that they reach in their analysis. So, of course, I have a very limited amount of hours. Okay, as every course. I mean, professors always want to have 200 hours. Unfortunately, I have just 15. So what I can do in class is quite limited. I can tell you that the approach is very proactive. So they have this platform. Usually they are ready to use it. Not big fears, let's say, with KNIME. What I noticed this year is that they've started to investigate online to find additional sources and to do something extra. The anonymization node, I've never ever mentioned the fact that there is an anonymization. I knew it, but I never mentioned the fact that there was an anonymization node in KNIME. So they manually did the research, installed, used it, understood, and they use it in a perfectly legal manner. And they were awarded with lode also because of that. So, yes. You should ask to Professor Palmirani because she's working with the European institutions to draft the legislation. There is a reference in the next slide. I'm just anticipating. The problem to draft the legislation in a consistent manner throughout all the European institutions. I guess that some of them, yes, they may use KNIME. Why not? I'm not aware of any specific person that is currently using KNIME in the European Commission, but I guess that in the communities that are working on the legal drafting, now with LLMs, large language models, ChatGPT, and similars, I know that technical people involved in the legislative drafting are experimenting. My guess is that some of them may also end up using KNIME. I think there is a question from the chat. Okay, Pietro, hi. Do you think this approach would be useful for a study of harmonized regulation from different countries? For instance, regarding international trade among all Mediterranean countries, including those outside the EU? Yes, the answer is absolutely yes, because you can calculate the difference. This is a study that I will show you in the second part. There is a study on harmonizing or understanding the difference between the national implementation of European directives, which are national law, in member states of the European Union. So there is one standard text, the European directive, and countries have to implement the directive into their national law. This is how directives work. You can calculate the distance between the national implementations to understand who did what, which states decided to derogate, to raise exceptions, to limit, etc., etc. And there is a study on this I will briefly mention, but all the references to all the studies are in the footnotes of the slides, so you can retrieve them. You're welcome. Okay. Other questions? Otherwise, we can move to part 2. Fine. Okay. Part 2 is about what I do where I don't teach and I don't spend time with my wife. That is legal informatics research. I'll basically give you some examples, but I wanted also to provide you with a perspective on the future. Of course, there is a lot of talk about artificial intelligence, the fact that there is a new piece of legislation. By the way, today was a very heavy morning for me, I would say, because while I was revising all the slides and changing the fonts, etc., the compromise text of the Artificial Intelligence Act was leaked by somebody in the press. So we have an unofficial text of the Artificial Intelligence Act of the European Union. You can imagine how happy I was this morning. This is what happened. So, I mean, these slides are also considering the fact that we are having an Artificial Intelligence Act in the near future. The approval is expected in March, April. And of course, it will become completely effective in a couple of years, or 6 months, 1 year, 2 years. From my understanding, this is how it's going to be. But by the end of this year, we will have an Artificial Intelligence Act. And I wanted to see how KNIME reacts to the Artificial Intelligence Act, because from a legal perspective, this is an interesting question. Okay. So I told you something about what are the problems of legal text analysis. There is a branch of research, there is my branch of research, legal informatics, that works at the intersection of law and computer science, computer systems in general. What I've listed here is just a list of topics that are covered by this very broad subject matter. Legal information retrieval, legal argumentation, legal XML, we have seen some examples, case-based reasoning, the interpretation of the law, legal ontologies, and many more, legal Q&A. Now, the law and large language models, there is still not an official name. LLM law doesn't sound that good, so I don't know. But there are many sub areas in the legal informatics research. And I wanted to provide you with some examples, okay? These are very short collection of studies. You can see the references in the bottom of the slide, including the DOE, so you can more easily access the paper. This is to answer to the question that Pietro was raising before in the chat. This is a study by Professor Palmirani, and basically she calculated the distance, the syntactic distance in bigrams between national laws and the European directive that those laws were meant to interpret. And there are some interesting results. Of course, I don't have the time to comment these results in depth, but the idea is that you can calculate how well member states have transposed directives. So when a member state is non-compliant with the obligations before the European Union law, there are tools to understand the amount of divergence. Of course, this is not about the significance of the divergence, but at least it's a quantitative analysis of how the two texts are different. And I remind you that if a member state is not compliant with the transposition of a directive, it can be subject to an infringement procedure before the European Commission. So this is interesting. And it's also part of a study that is called LEOS, Drafting Legislation in the Era of AI and Digitalization. This is also freely accessible. You can use it just to understand how the research is integrating with the lawmakers and the legislative domain. This is mine. This is a 3D visualization of some cases. So what you see is here are Italian cases on drug micro trafficking. In Italy, our jurisdiction is split, let's say, because there are some cases that are considered to be serious or non-serious. In Italy, we'd say lieve entità, non lieve entità, about drug trafficking. So I extracted some elements, legal elements, of course, such as the number of doses that have been traded, the kind of substance, the drug, cocaine, marijuana, or heroin, and so on, the number of days of punishment, and the punishment in the pecuniary punishment in euro. And I represented them in a 3D visual space where I can understand whether there are trends or not. This is, I think, even more interesting because I understood, I understood what is the main criterion that judges use to differentiate between serious and non-serious offenses. In Italy, we don't have a fixed amount or a fixed criterion. It's not about the number of doses, let's say. It's completely up to the judge. So the judge can decide whether the case is serious or non-serious on the basis of some random elements that are kept into account. Of course, we have our Court of Cassation, our Corte di Cassazione, that gives indications, criteria to judges, but judges are always free to be to decide independently. One question, given the case law that I had, was what are the legal factors that actually differentiate serious from non-serious cases? And I found out that it's the number of doses. Okay. And I did it thanks to a decision tree. Of course, this is a machine learning, supervised machine learning algorithm, and that I used in an explainable way. We'll talk about explainability at the end. But the idea is that I am having a very transparent quantitative assessment of what judges have decided and why judges have decided on the basis of a quantitative elements such as the number of doses, the percentage of chemical substance, and so on and so forth. All of this was done with KNIME. I think I can also provide you a very, no, I don't have it here. No, I don't have it open. It's fine. But this is just the final result. Okay, how about LLMs? Now there is a huge talking about large language models. Apparently, I've read articles such as ChatGPT can pass the bar exam with a very high rate of success. So the intuition, still not so much confirmed, is that LLMs in general are, let's say, very good in executing legal tasks and legal reasoning. Of course, we are not sure about to what extent they are good in solving legal problems. Understanding how they work for the perspective of a lawyer is definitely something good. And KNIME is actually helpful for it. With KNIME, for instance, I managed to create a workflow by integrating Llama. Okay, this is the full workflow. There are some Python scripts, there are some views, there are some data manipulation with KNIME. I don't have the time to re-execute everything because this takes a lot. But basically what I've done is was integrating Llama. There is open source large language model similar to ChatGPT, but provided by Meta, completely open source and freely available. I used it in KNIME to visualize how the system, the LLM, changes when the instruction to the system is given in a certain way. For instance, by stressing you are an assistant legal drafter, your task is to draft law. What I noticed, thanks to these visualizations, is that you can manipulate the outcome by shifting the internal parameter of attention of the large language model in a particular way if you use it in a, let's say, if you use some system prompts that are written in a particular way. So this is helpful for legal informatics research on LLMs. We can explain, for instance, how the internal parameters have changed and explore to what extent LLMs are powerful in the legal domain. And again, as you have seen from the workflow, all of this was done with KNIME, including the integration of Llama and the visualizations. I actually had a dashboard, but again, I don't have time to rerun everything because that takes way too long. Okay, something about some words, interesting words about trustworthy AI. So again, fortunately or unfortunately, my legal background always comes up. So when I deal with machine learning algorithms, when I deal with artificial intelligence, I have to keep into account the fact that laws exist. And before laws, we have also ethical principles. And all the ethical principles are about ethical, the idea of a trustworthy AI, an AI system that we can trust. I have to mention you that there is a forthcoming piece of legislation that is called Artificial Intelligence Act that classifies artificial intelligence systems on the basis of some categories. Right now, the categories are the following. Of course, this is still under debate, but right now, the categories are the following. We have banned systems, high-risk systems, limited risk systems, and minimal risk systems. In the high-risk systems, there are some AI that deal, for instance, with medical devices, mobility, and predictive or assistive justice. So now imagine a system, sorry, I have to get back to this. Imagine a system that tells our judges what's the general trend in the case law about drug micro trafficking. This system is a system that can be used to assist the judge, or if you want, to predict the outcome of the ruling. Because if I give to my system all the data that it needs for a new case, it can predict whether the case should be a serious or a non-serious offense. And this will be heavily regulated under the Artificial Intelligence Act. So systems that are built like the systems that I showed you, including the very first one, will be subject to heavy regulations. Also, other systems, many other systems will be subject to these heavy regulations, and lawyers are not yet equipped with tools that allow us to understand how and whether these systems are actually compliant with the law or not. Moreover, this is from the legal perspective, from the perspective of a lawyer. Moreover, there is a mandatory for these high-risk systems fundamental rights impact assessment, which means that AI providers should use checklists and other tools to understand whether their systems may pose question to fundamental rights. I want to focus on two requirements, fairness and explainable AI. There are two key requirements in the Artificial Intelligence Act, especially for high-risk systems. So there will be demand for this kind of assessment. Can KNIME help the assessment and the evaluation of high-risk systems, at least in fairness and explainable AI? Okay, first, let's see what is this fairness and in the wording, because we have to, as from a legal perspective, we have to keep it about the wording of the regulation. This is the version that was leaked today. So this is brand new. I guess it's the first time you see this. In a nutshell, training, validation, and testing datasets should be subject to some practices. These practices should concern the examination of the system in the view of possible biases. This is, of course, to avoid algorithmic bias, so prejudice against individuals. And this is Article 10, which means two things. This provision has two consequences from a legal perspective. First, AI system providers should assess whether their system is fair or not. And second, judges and authorities in general will have to evaluate whether the systems are compliant or not with the law. In a nutshell, it means that we need tools. There is nothing else to say. We need metrics, we need methods, tools to understand if a system is fair or not. Apart from the checklists, okay? For that, you can ask my wife, she's here, and she's also working on fairness checklists specifically for her PhD. So it's not my job, but I know, also thanks to her, that there is the necessity of assessing the level of fairness through checklists. Okay, let's see what happens with KNIME. There is a component, I'll show you how it works, that relies on three fairness metrics that are used in the, I wouldn't say they've been approved because still there is a lot of discussion, but at least in the literature, these metrics are known, discussed, and perhaps they will also become parts of the standards of and the state of the art of artificial intelligence systems. Okay, what are these metrics? First, demographic parity, equal opportunity, and equalized odds. These metrics use in KNIME three variables. The advantage class, so something positive that can happen, such as survived, or your loan has been accepted, or you have been accepted to an hospital, or you are innocent, you are not guilty, something positive that can happen as an outcome of the predictive model. A sensitive attribute, there is the attribute that can raise issues of discrimination, gender, ethnicity, philosophical opinion, political opinion, and so on and so forth. And unprotected classes that are, of course, understood on the basis of the sensitive attribute. Female, migrant, Afro-American, Italian, in some instances, and so on. Okay. Now, some very short words about these metrics. Demographic parity checks the dependency of the prediction of a model, the relationship between the prediction of a model and the sensitive attribute that we identified before. So again, the sensitive attribute, for instance, was gender or ethnicity. How much does the predictor rely on that sensitive attribute to predict something? Equal opportunity focuses on false negatives, so on mistakes. For instance, it checks whether the advantage class was the performance over the advantaged class or the disadvantaged class was superior in terms of quality. So the model had a better performance over certain classes against unprotected groups. Equalize also considers false positives, which basically means the level of accuracy towards protected and unprotected groups. In KNIME, these metrics are available thanks to a node that is called fairness scorer. As a rule of thumb, all these numbers, you will see numbers, have to be 1. Okay, as close as possible to 1. Okay, let's see in practice what happens. I took the very famous Titanic dataset that is used in many computer science challenges, and in general, it's very used in in computer science. Basically, the model, so the machine learning model, has to predict whether a person should survive or not a shipwreck, based on some information that is available: the name, the gender, which would be our sensitive attribute, the age, the number of relatives in the ship, the class, and so on and so forth. So the idea is that the model has to be able to predict whether a person will survive or will not survive a shipwreck. Of course, the advantage class is to survive the shipwreck in this case. Okay, now this we can, well, I can also show it here because I think it's relatively clear. So I have this Titanic dataset. As with any machine learning, supervised machine learning approach, I separate the dataset, 80% for the training, 20% for the test. Right now, this is very important. The composition of the dataset is unbalanced. I have more males. Okay. What I'm expecting is that there can be a bias against women. This is what I'm expecting here. And everything else is super easy. I'm using a supervised machine learning algorithm that is the gradient boosted trees, again in the family of the trees, with the learner and the predictor. The learner will learn how to classify the survived from not survived. The predictor will predict for new cases, and the fairness scorer will tell us whether there is a gender bias or not. Okay, now I've run the same experiment twice. The first time with an imbalanced dataset, the second time with a balanced dataset. I removed, thanks to a node that is called equal side sampling, I removed some males in order to have a 50-50% balanced dataset. So in the training dataset now, I have a perfect balance between males and females. What's the hypothesis here? The hypothesis here is that by having a balanced dataset, the gender bias, if any, gender bias will be removed. And truly, I was right, because I could assess and compare the different metrics that I calculated in the first workflow and in the second workflow. Basically, what happens is that there is an increase here. The increase is considered to be as close as 1 as possible. Of course, in terms of demographic parity, the fairness is lower, but this is normal because I have less data. So the learner has to learn more, has to rely more on the sex variable. Instead, for the other two metrics, I clearly have a positive impact, in particular for the equality of opportunity. There is a sensitive increase in the overall fairness of the system. Tools like this will be necessary under the AI Act, because this will allow judges, authorities to understand whether a system is fair, whether by manipulating data, the system can be fairer. And also, I'll go back to this, whether there is a breach, an infringement of this article. At the end of the day, tools and metrics like the one that I just showed you will be helpful in also understanding the level of bias and whether the AI provider could have done something to remove the bias in the dataset. Okay, second element, it's the Artificial Intelligence Act, Article 13. This is about explainability and explicability. The article, again, in the latest leaked version, that is the most updated version that I have to date this morning, says that high-risk AI systems shall be designed and developed in such a way to ensure that their operation is sufficiently transparent to enable deployers, users, to interpret the system's output and use it appropriately. Now, this provision is complicated because, of course, the definition of explanation itself is still disputed in philosophy. So having a piece of legislation that tells us that systems should be somehow explainable is a complex legal operation. There are possibilities for global explanations, local explanations, there are metrics, but explainability metrics should have particular requirements under the Artificial Intelligence Act. Otherwise, they will not be helpful for the purposes of the AI Act. So there is a node, say, it's not only a node, it's more than that. Of course, now, oh no, okay, it's here. It's okay. No, here, I wanted to go here. There is a very interesting node in KNIME. There is this local explanation view. So imagine I am a judge and I am passionate about computer science. Imagine that I know more or less the basics of KNIME, and I want to see whether I should decide a case like in the case that we discussed before as a serious infringement or a non-serious infringement. What I can do is to build a very simple, simplified pipeline with some algorithms that try to classify on the basis of my previous cases whether a system is, whether a case should be decided as a serious or a non-serious infringement. I use auto machine learning. Basically tells me what's the best algorithm. I choose one, let's say, and I want to see how it performs with a new case, a case that has just been brought before me. Well, I have performance, I have a classification, but why do I have this classification? This will be mandatory under the Artificial Intelligence Act. So this is something that we have to deal with. It's unavoidable. There is a node that is very helpful. It's called Local Explanation View, and it provides a very, very detailed report on what are the factors that led to an output by the system. This is extremely interesting also from the perspective of a lawyer, because there are explanations. We know why the system has decided in a specific way. Now, if we combine a system like this with all the considerations that I gave in the last hour and a half, we can also evaluate these systems from a completely legal perspective, also in the case system like that is used in predictive or assistive justice. New case is brought by the judge runs the algorithm tells, okay, should be a serious case. Why? There is a full explanation. Now, there is an open question. Is this explanation enough? Can there be another explanation? What's the purpose of an explanation under the Artificial Intelligence Act? Will this be enough? I don't know. On the right-hand side, we have counterfactual explanations. And these are basically very similar cases that have been decided in opposite ways. And this is extremely important as well, because they provide us with a different way of approaching explanations. And I'm very happy that KNIME provides these kind of tools, because also they facilitate my job as a as a professor, as teacher, for teaching what an explanation is, what are possibility in explanations. Now, the law is complicated, and there will be interpretations on the concept of the right explanation under the Artificial Intelligence Act. But this is a good starting point. At least there is something. When we talk about explanations, then we have something. We have a benchmark, something that can be helpful, that lawyers can easily access, because as you can see, it's a very small, naive experiment. And this is very positive news. Okay. Some conclusions, because yes, I think it's time, so that we also have some time for questions. So some conclusions. The KNIME can be used in legal informatics research. In general, these data analytics tools are powerful. They allow the prototyping of applications. You have seen it in the first studies when we were talking about the how I use it in my research, developing small cases of predictive/assistive systems for judges, for legal professionals in general. But at the same time, they provide, KNIME, more specifically, KNIME provides us with a deeper and I would say better understanding of what the law really wants. For instance, when we talk with my wife about what fairness is, this is a research topic, or with my colleagues about what explainability is, now from a legal perspective, I have a much better understanding of what systems and tools like KNIME can actually do to support the correct implementation of the Artificial Intelligence Act. And when I discuss them, I can, as a lawyer, I can also take into account what's the data scientist perspective on certain topics. At least there is a common language. And I think that KNIME is a good enabler of such common language, such common vocabulary between law, in this case, philosophy of law, because at the end of the day, what is an explanation, what is fairness, what is justice, and so on, are also questions that revolve around philosophy of law, and at the other end of the spectrum, also data science in general. Okay, that was it. Thank you a lot for listening, for staying with me until the very end. These are my, this is my email address, so anytime you can email me, and I'm more than happy to answer to your questions via email later, tomorrow, month, etc. Thank you.